All rise, please. Good afternoon all. This afternoon we have a Court of Appeal hearing before presiding Judge Chief Justice Michael Hwang, Justice Sir Jeremy Cooke, His Excellency Justice Omar Al Muhairi. This is in case number CA-009-2018, VTJ Limited, the appellant, and Mohd Ammar Al Hassan, the respondent. The appellants are represented on your right, Your Honour, by Global Advocacy and Legal Counsel. Lead counsel is Michael Patchett-Joyce, instructed by Sharon Markham. The counsel for the defendant and respondent, I should say, on your left, Your Honours, is United Advocates, led by Maria Robert of that firm, assisted by Amanda Lewis of that firm.
Good afternoon, Mr. Patchett-Joyce.
Your Honours, as you've heard, I appear along with my co-counsel on behalf of the appellant claimants and her own friend, Ms. Robert, assisted by Ms. Amanda Lewis here on behalf of the defendant respondents. The court should have 3 bundles before it, comprising 2 bundles of documents and 1 bundle of authorities. So far as the particularly relevant documents are concerned, it will take bundle 1 behind tab 2. Your Honours will find the judgment from which or against which this appeal is brought. Then at tab 4, Your Honours will find the appellant's skeleton argument. Tab 6, the respondent's skeleton argument. Tab 7, the appellant's response. And tab 8, the respondent's response. I can provide the dates of each of those documents if it's of any help, but they're all dated internally. Tabs 9 and 10, the Honours will find chronologies submitted by and on behalf of each respective party, but it may be that this is not a case in which the chronologies need to be looked at in any great detail because there's no minutiae of timing involved. And thereafter, Your Honours will find the pleadings and the evidence before the court of first instance, with the documents being arranged in chronological order, which is in keeping with the court rules, and Your Honours will find at the beginning of bundles 1 and 2 an appeal bundle index, which we hope, and I'm sure this is a joint hope, is of assistance to the court in hearing this matter. There is one further matter that I should indicate to the court, and that is at the end of bundle 2, Your Honours will find that there is behind tab 84 a transcript of the hearing at first instance. And it does run to 118 pages, and it seemed to me that it would be sensible if I reduced that to an index for the transcripts, which I've done, and that has been provided to the friend, I think, today or the day before yesterday, but it's only 1 page. She's kindly indicated that she's had an opportunity to consider it, and with Your Honour's leave, I'll pass out copies. I tried to get it on 1 sheet of paper and succeeded in that endeavour, but the result is that it's in rather small font, so I apologise for the smallness of the font, and I must immediately apologise to her friend for, on several occasions, misspelling her name with a P instead of a B. It should be Miss Robert.
Can you first of all help by identifying who has filed which chronology I don't know why in this jurisdiction people don't identify the documents that they file by reference to the party that's filing it. So I've got two documents, both called chronologies, and I don't know which one is filed by one party.
Yes, behind tab 9 is the appellant the claimant appellant's chronology, and behind tab 10 is the defendant respondent's chronology.
I have them loose, so can you just identify them? There's one which is 2 pages and one which is 3 pages.
Yes, Your Honour, the one which is 3 pages and has on its first page dates running from the 29th of March through to the 2nd of October 2012. That is submitted on behalf of the claimant appellant, and the other document which has its frontispiece chronology and then the dates are set out on the succeeding couple of pages submitted by the defendant respondent.
And position is as before that the second defendant is not appearing.
That's correct. And I think there may be a court order releasing the second defendant, but that was before the involvement of either myself or my co-counsel. So that is said with an endeavour to assist the court, but not with certainty of knowledge in what I say.
Okay.
Your Honours, it's probably convenient if I begin with the brief facts before taking Your Honours to the skeleton arguments. The case arises out of the purchase of retail commercial property, which is identified more particularly in the pleadings and is known throughout the case as the capital U unit, which is a property in the DIFC Park Towers development. The developer of the property and the original vendor of the unit was Damac Properties, and Damac sold the unit to the defendant respondent in March 2012 by an agreement to sell dated the 29th of March 2012. On the claimant appellant's case, there was a further agreement known as a Memorandum of Understanding to sell the unit, and that Memorandum of Agreement was entered into between the parties, namely the defendant respondent and the claimant appellant, by the Memorandum of Understanding dated the 19th of April 2012. And what is said on behalf of the claimant appellant is that, in essence, the claimant appellant stepped into the shoes of the defendant respondent, so that while so far as Damac was concerned, the defendant respondent was the purchaser of the unit under the March 2012 agreement to sell, in fact, the claimant appellant was providing funds paid over largely, but not wholly, in cash, and we'll come back to that, under the April 2012 Memorandum of Understanding. The claimant appellant says that it has paid everything under the March 2012 agreement to sell and under the April 2012 Memorandum of Understanding, and accordingly is entitled to the transfer of the unit. On the defendant respondent's case, an agreement to sell with regard to the unit was indeed contemplated between the defendant respondent and the claimant appellant, but only contemplated by a Memorandum of Understanding dated the 9th of September 2014, but that agreement certainly not concluded and is in dispute so far as the claimant appellant is concerned. So the position, Your Honours, is that the claim is essentially premised on the Memorandum of Understanding of April 2012, and it's said that payments, the cash payments in large part that I have described, were made by an individual called Mr. Chiro Adiana, and that in making those payments, Mr. Ariana was acting on behalf of the claimant appellant. So far as the defence and counterclaim is concerned, when one's looking at the pleadings, that is essentially premised on the claim that the payments in cash were made by Mr. Ariana on behalf of the defendant respondent, and the defendant respondent also bases its case on the second memorandum of understanding of September 2014. But as that underpinned the counterclaim, and as there is no appeal against the court in first instance finding in relation to the counterclaim being dismissed and there's no respondent's notice, then the counterclaim is not before this court. So the question, the key question, really boils down to quite a simple question: on whose behalf was Mr. Ariana acting when he was making these payments? It's complicated slightly by the fact that there is another entity involved called Allianz Property Estates, and Allianz, A-L-Y-A-N-S, was the corporate vehicle through whom Mr. Ariana, on whose behalf Mr. Ariana was acting. So he wasn't acting in his own capacity. He was acting in his capacity with Allianz. So it may be that the question is, on whose behalf was Allianz acting when the payments were made? So whether one's looking at the payments being made by Mr. Ariana in a personal capacity or Allianz in a corporate capacity, it really boils down to the same question. The judgment, which, as I've indicated, is to be found behind tab 2, and the operative parts of the judgment begin with the discussion that the judge enters into at paragraphs 25 through to 32 of that judgment. The judge, in summary, for present purposes in setting out the case before your honours at this stage, the judge found that the claimant had not proved its claim and that the defendant had not proved its counterclaim, and therefore on that basis both claim and counterclaim were dismissed. As I've indicated, the claimant appellant sought permission to appeal against the dismissal of its claim, and that permission was granted by order of the trial judge, dated the 17th of July, and that order, for your honour's reference, is to be found at tab 3 in bundle 1. As I've indicated, there is no cross-appeal nor respondent's notice in relation to the dismissal of the counterclaim, and therefore, in essence, 2 points are raised in this appeal by the appeal notice. The first and the substantive point is that we say the decision of the trial judge in relation to the claim was against the weight of the evidence, and clearly so. We're also concerned, and put this in a slightly different category, because the first ground we say is a ground on which we have a reasonable prospect of success, and that was the basis on which we sought permission to appeal in that regard. The second ground really falls under the some other compelling reason, because it is more process and procedural than substantive, and it's this: fraud was pleaded against my client, VTJ Limited. So there was a distinct allegation of fraud, but the allegation was certainly not distinctly proved, and we say that on investigation there was no reasonably credible material on which an allegation of fraud could be advanced, and therefore it should not have been advanced. And we raise this because it is obviously a matter of concern to any person, whether natural or legal, but in this instance a legal personality, for an allegation of fraud to be raised on a pleading, which is a public document, and then not to be followed through in evidence or at the hearing. So we say there is a matter of concern in that regard.
The point was never put to Mr. Harian in cross-examination at all.
No, absolutely. And we make that point in the Senate document. I've sought to address that point as best I can through the index of transcripts. I'm obviously demonstrating a negative, and to demonstrate a negative by going through 118 pages, there's really no substitute for doing that exercise.
Well, there's only about 20 or 30 pages.
There are only about 20 or 30 pages.
Cross-examination of Mr. Harian.
Yes, and it just wasn't put to him. Lord, having set out the case by way of an overview, may I now turn to the appellant's skeleton argument, which, as I've already indicated, the court will find behind tab 4.
Of volume 1.
Of volume 1, yes. Tabs 1 to 42 are contained in volume 1, and tabs 43 to 84 are in volume 2. Your Honours, I don't need to detain the court with paragraph 1. So far as paragraph 2 is concerned, this carries over the grounds of appeal and summarises or sets out more fully matters that I've already summarised. Paragraph 3 sets out the orders sought by the claimant appellant on this appeal, and then at paragraph 4 to 6, this is dealing with procedural requirements of Part 44. No witness statement or affidavit is needed in support of the application. The chronology that I've already indicated accompanied the skeleton argument, and the skeleton argument is served in accordance with the time limit stipulated.
But we're past that stage, aren't we, Mr. Patrick Joyce? Leave has been granted, so you probably should only highlight to us some point in this application which is more fully fleshed out than in the supplementary skeletons that have followed. So if you want to develop an argument from here, that's fine, but the question about what you need to put up in order to support the application for leave, I think is academic now.
I'm very grateful, and that does have a relevance in relation to a point which is raised by the learned brethren, and that was procedural lateness. So it may be convenient if I just interpose that. I don't even know whether the learned friend is pursuing the point in relation to procedural lateness, because it arose most clearly in written submissions before permission to appeal was granted.
Yeah.
And it is there, there's a shadow of it there in the learned friend's skeleton argument. But it isn't really explored in the skeleton argument. It may be that it's fallen away.
Can we just have that clarification, Ms. Rubert?
Yes, happy to. We did raise it at onset. We were satisfied with the decision of the court in accepting, and we decided not to pursue on that angle, on the procedural timings.
Thank you.
Well, I'm very grateful, and certainly that saves a number of paragraphs and shortens proceedings. I'm very grateful to the learned friend. Your Honour, perhaps at this stage, I could inquire of the court in light of what you've said, Your Honour, as to what extent the court has already had an opportunity to look at all of the skeleton arguments. And I don't want to weary the court by going at a pedestrian pace, and I don't want to lose the court by going too fast. There is another matter which I am aware of, and that is that by reason of the ordering of the documents, putting them into chronological order, they then are disturbed from the order in which they were to be found in the file at first instance. So that when the submissions came to be drafted, the present bundles hadn't been pulled together, and therefore there was no scope for cross-referencing with this document's at tab so-and-so, that document's at tab such-and-such. And what I have done is I've done that in the text of my own submissions, and it may be convenient if I go through those submissions, indicating where the documents are to be found for the court's convenience, even if the court has had already a very full opportunity to read the skeleton arguments and is therefore fully appraised of the arguments in their substance.
I think let's manage with what we've got, and if we have difficulty, then you can assist us on an ad hoc basis.
Absolutely, Your Honour. And what I'll do is I'll read into the transcript the reference without necessarily taking the court to it, and that way it will be readily available for the court's further consideration without, I hope, undue delay in the submissions I make.
Yeah.
I hope that's convenient, Lord, Your Honour. So picking up the skeleton argument, paragraph 9 expands upon the first ground, namely that the CFI, of course, first instance, came to a conclusion that was against the weight of the evidence, and in relation to the allegations of fraud, we refer to Armitage and Nurse, and also Metcalfe and Weatherall. Those cases are available to the court in bundle 3. They are cited for very straightforward principles, namely so far as Armitage and Nurse is concerned, that fraud must be distinctly alleged and distinctly proved, and that of course goes back to David and Garrett back in the late 1880s. That is to be found in the judgment at page 256F, which is 256F of the formal reports. It's actually to be found at page 56 of the internally paginated.
But can you show us the document which is supposed to have been... The fraud, is it by way of forgery, is it?
Well, there are two allegations of falsity. First of all, the document, the Memorandum of Understanding in September 2012, that was to provide the very wording of the statement of defence and counterclaim. It was said that a signature had been forged, and such an attempt is illegitimate, deceptive, dishonest, illegal, and fraudulent. That's paragraph 4 of the statement of defence, which is to be found in tab 13, page 99 of the bundle.
What? Bundle 1?
Bundle 1, tab 13, page 99. Uh,
99 is the internal pagination, or
the pagination to rely is the one in the very bottom right-hand corner,
yeah.
where where it says page followed by, in this instance,
Yeah.
99.
Sorry, which paragraph are you reading?
Paragraph 4, and I read from the 4th and 5th lines. The sentence begins at the end of the 3rd line. The first defendant notes that his signature has been forged, and such an attempt is legitimate, deceptive, dishonest, illegal, and fraudulent. And then going over the page to paragraph 11 on page 100. This leads to paragraph 14 of the particulars of claim, wherein the claimant claims to have attained discount penalty fee. This is false.
Is it 11?
Yes, paragraph 11 of the statement of defence feeds in respect of paragraph 14 of the particulars of claim. So paragraph 11 on page 100. we deal with this more fully, obviously, in our skeleton argument, but in terms of the legal text, which is what I'm taking the court to at the moment, then we have in the authorities bundle at tab 3, at tab 2, internal page 56. Which in the official law reports,
authorities.
the authorities bundle, if you want to just look back one page to page 55, about 2/3 of the way down, in light grey italics, it says 1998 Chancery 241, page 256. So we know that.
I'm looking at paragraph, page 55 of the case report.
I'm looking at, again, looking in the bottom right hand, page 55. There is also page 15 on the top.
Yeah, and which part of the page were you just reading from?
About 2/3 of the way down, Your Honour, on the right-hand margin, in light grey, it says 1998 Chancery 241, page 256.
Yes.
So that's just to identify the correct page number.
Okay.
And then, Your Honour, if Your Honour turns over to page 56 of this bundle, at the head of that page, there is an internal heading, Do the Pleadings Allege Fraud? And then 3 paragraphs further down, you have a paragraph beginning, The general principle is well known, fraud must be distinctly alleged and is distinctly proved. Davey and Garrett, 1878, per Lord Justice Thesiger. And then it goes on to talk about Belmont Finance and Williams Furniture. But it's, in our submission, a very straightforward legal principle. We've just supplied appropriate case law authority for a very straightforward legal principle.
Let's worry about the pleading point a bit later.
Okay.
I mean, I think they've given you sufficient indication of the case you have to meet, and which you have. So let's see what the issues are and how you engage with
Yes,
those
sure.
issues.
I'm happy to come back to that. It was just that in the sequence of going through the skeleton, the case law was referred to, and I'm in your Honour's hands as to whether it's convenient to deal with the case law to the extent that's necessary when we reach this point in the argument, or whether it's helpful and convenient to know the case law in advance. But let me turn to, in that case, back to tab 4 in Bundle 1 and page 19.
Back to your skeleton.
Yes, indeed, back to the skeleton. Order.
Yes.
And I'm picking it up on page 19, and there's an internal heading, the background circumstances. And in paragraph 13, which is the following paragraph, we see reference to 2 documents which I've already introduced, namely the agreement to sell in March 2012, and for the court's reference, that's to be found at tab 17, and the Memorandum of Understanding, dated the 19th of April 2012, and for the court's reference, that is to be found at tab 19. It's then, or we then set out the parties to the agreement to sell and more circumstances in paragraph 15, and we do the same in relation to the Memorandum of Understanding at paragraphs 16 and 17. And at paragraph 18, we make reference to a particular clause in the agreement to sell. That is in tab 17, so the same bundle. If I can invite the court just briefly to turn up tab 17, Your Honours will see that it comprises 2 pages. Pages 120 and 121. And at page 121, we find numbered paragraph or item 10.
You want us to turn to 121?
Yes, so it's tab 17 in bundle 1, and it's the second page, page 121.
Handover milestone.
Indeed. Item 10, paragraph 10, handover milestone after 100% payment of the purchase price. It's a rather self-evident point, but it's there on the face of the document, on the face of the agreement to sell, namely that handover will occur only after 100% payment of the purchase price has been made.
This copy only has one signature. Oh, sorry, the vendor signature is on page 1, is it?
No, because page 120 is Mr. Al Hassan's signature as well.
He doesn't have one signed by the developer.
It doesn't, but this is, Your Honour, the agreement to sell, and what we will see is that, in fact, the handover milestone is reached, and reached quite clearly. So I take Your Honour's point about what the face of the document shows, but in our submission it won't be pivotal or material to the analysis that I'm taking the court through.
But it's got common ground, there was such a sale.
Essentially.
Please go on.
If I can then take the court back to page 20 and paragraph 19 of the skeleton argument, Your Honours will see at that paragraph there is reference to a completed handover checklist retail from Damak. Now that, for the court's reference, is to be found behind tab 41, and there is a further copy behind tab 42, but tab 41 has signatures and stamps on it, so it's convenient just to look at tab 41. We see that it's a document, handover checklist retail. Reading down, we can see that it's in relation to this particular unit, DFRP 430. We have the date of the 22nd of April 2013. And therefore we have very substantial proof there that full payment has been made, because otherwise there wouldn't be scope for a handover checklist retail. But then if I can invite the court just to take the second bundle and look behind tab 43.
Which bundle?
The second bundle, bundle 2, and it's the first of the tabs in that bundle, tab 43.
Yes.
And Your Honour will see that that is a document entitled Payment Clearance Certificate. It's dated the same date as the handover checklist that we've just seen, namely April 22nd, 2013, and it reveals or evidences the final amount having been due and paid, so that so far as DAMAC is concerned, we know that full payment has been made.
Yes.
So that, in essence, is going back to our skeleton argument on page 20, paragraph 21.
Paragraph 21.
21. On the basis of the material and the evidence that I've just taken the court to, we say there can be no doubt that the condition precedent expressed as the handover milestone has been fulfilled. Paragraph 22, the key questions, therefore, are how, by whom, and on what basis. And at paragraph 23, I summarise the claimant appellant's case, which I've already done, and therefore I won't detain the court with repetition, but there's a short summary of how we put our case there. And then, for fairness, paragraph 24 is an attempt, I hope an accurate attempt, to summarise the defendant-respondent's response to that case. And then at paragraph 25, I indicate that the defendant-respondent puts his case on the basis that he executed a completely different memorandum of understanding in September 2014. For reasons I've already indicated, that tends to fall away for present purposes, but should the court want the reference, it's to be found at tab 49. And then at paragraph 26, we make reference to a statement of account from DAMAC, the most complete statement being that dated the 4th of April 2016, and that document, Your Honours, is to be found in bundle 2 behind tab 55. It's a two-page document, but for present purposes, I think we only need to look at the first page, which is internal or bundle page 236. Just to identify the document, Your Honours can see the heading Statement of Account as on the 4th of April 2016. And then if I invite the court to look 5 entries down under the transactions in AED, which is the third heading as one reads down the left-hand margin. The 4th entry under that heading, there is reference to cheque number 00006, Emirates NBD, so National Bank of Dubai, and the credit of 272,000 dirhams is identified there. And whilst we're on this page, may I take the court to almost the foot of this page, to the antepenultimate and immediately preceding 2 entries. So there are 3 entries altogether which I would invite the court's attention to, and it's best identified by counting across the columns, 1, 2, 3, 4, 5 columns under the title description. Your Honours will see that the description of those 3 entries that I've taken the court to all relate to penalties. Penalty as of February 2018, penalty waived, and additional penalties in March 2013. So, distilling that into writing back to skeleton argument, if I may, page 21.
Page 31 or
page 21
of
the bundle 1, so behind tab 4.
What was the tab?
Tab 4.
It's your skeleton?
It is my skeleton indeed, Your Honour, and I'm picking it up now at paragraph 27, just to draw matters together from what we've seen. It's immediately apparent from the statement of account that although many of the transactions were in cash, a payment to Damat of 272,000 dirham was made by cheque, credited to the account on the 20th of May. We'll come back to that 20th of May 2012. It's also similarly apparent that penalties were imposed by Damat in February and March 2013, which obviously would need to have been paid before the requirements of the handover milestone, which I've already taken the court to, would have been satisfied.
What were the penalties for?
I'm sorry, I missed that, Your Honour.
What were the penalties for?
The penalties were for late payment, and I'll come to show the court the evidence in relation to the penalties and also the mitigation of the penalties, which on the present facts is particularly important. So it is a very material element which I'll take your honour to in due course.
Yes?
For convenience, we've broken it out into dealing with cheques first and then penalties. So I will come back to answer your Honour's point fully in due course, if I may. But just looking at the cheque payments first of all. The claimant appellant says that payments of other charges or costs relating to the purchase of the unit were made by cheques drawn on its instruction and behalf, namely two cheques, a cheque in March 2013 and a cheque in May 2015. The first cheque, dated the 25th of March 2013, in the sum of 36,000 odd dirhams, was drawn on the Taylor Wessing Middle East LLP Dubai branch client account, and that is to be found at tab 31
Of bundle?
of bundle 1. Internal page 153. So Your Honours will see the date that it was, the payee was Luxury Facilities Management. It's a Taylor Wessing Middle East, etc. client account cheque, as is demonstrated by the print above the signature. And we also have the cheque number, which is 603154, forming the first 6 digits of the long string of barcode style or computerized digitry at the foot of the cheque.
Right, do you see a name of the...
The name is above the signature, reading in from the left-hand margin. Taylor Wessing Middle East LLP Dubai client account.
Ah, sorry. Yes?
So in essence, there are 4 matters that I draw to the court's attention: the date, the payee, the drawer, and the number of the cheque, 603154. If I do a similar exercise in relation to the second cheque, I'm afraid that means going to the second bundle and turning to tab 48. this, as the court will see, is dated the 15th of May 2014, and in very small print below the date it says valid for 6 months from the date of issue. It's in the sum of 78,300 dirham. It bears all the hallmarks and has been described as a manager's cheque. We see in the bottom left-hand corner the Royal Bank of Scotland plc payable at par at Dubai and Abu Dhabi branches. And above that printed rubric we have a long number beginning 7331 and continuing, and we also have the number of this cheque, which is 997232.
What's the significance of the number?
Well, it is significant because it demonstrates that a subsequent attempt to make payment some months after the date of this cheque, but within its validity, i.e. October 2014 rather than May 2014, was in part comprised of this cheque, and I'll make that good when I come to the relevant document which evidences that. Now, we have set out...
Who has paid this cheque? The name is not very clear.
The name
It's an obvious managers.
under the
Garbage
signature,
managers.
it's like Ravinder Singh.
Right.
So I will come back to the relevance of this cheque in due course. Now, the claimant appellant's case in relation to the cheques is set out in the particulars of claim, which is to be found in tab 12 of bundle 1. At paragraphs 10 to 12, which are on internal page 92, and paragraph 19, which is on page 93. And it may be convenient if I just invite the court either now or at some other convenient moment just to look.
Which bundle is this, sorry?
It's bundle 1, tab 12. The cheques are dealt with at paragraphs 10 to 12, and although it doesn't refer to the cheque, paragraph 19. Let me perhaps just take the court to paragraph 12 on page 92.
Yes.
Paragraph 12 is in the following terms: upon completion of all payments to the developer, the claimant instructed its then counsel, Messrs. Taylor Wessing Middle East LLP Dubai, to make payment of the community fee on behalf of the first defendant in the amount of 36,000 dirham to luxury facilities management, the designated facilities managers to the development. This occurred on the 25th of March 2013 via a cheque drawn on, and then it gives the client account, which we've already seen on the face of the cheque. And then paragraph 19 over the page other check, due to unforeseeable delays, the first defendant and the claimant only attempted to finalise the transfer of the unit in May 2014. They approached the second defendant with payment of the then 3.5% transfer fee. The aforementioned transfer fee was to be charged against the old valuation as set out in paragraph 16. And then perhaps for the sake of completeness, and again I'll make good the reason why I do this very shortly, but I take the court to the next page, internal page 94 and paragraph 25.
The skeleton?
No, paragraph 25 of tab 12. I'm going through the particulars of claim. So I've taken the court first of all to paragraphs 10 to 12 of tab 12, those paragraphs being on page 92. Then I've taken the court to paragraph 19 of particulars of claim, tab 12, page 93, and to complete this section, I'm taking the court to page 94, paragraph 25 of the particulars of claim. That's in the following terms: the claimant instructed its then counsel, Messrs. Taylor Wessing Middle East LLP, to deposit the second defendant's transfer fee, 5% of the new valuation. Messrs. Taylor Wessing Middle East LLP did so on the 2nd of October 2014. So that in both paragraph 25 and 2 pages earlier on, paragraph 12, the particulars of claimant expressly pleaded that Taylor Wessing was the claimant's then counsel. So, reverting now to tab 4 and the skeleton argument, I'll pick matters up at paragraph 31, if I may, Your Honour.
31 of what, sorry?
Of tab 4.
Reading.
Bundle 1, tab 4, which is our skeleton argument.
I have the skeleton loose, that's why.
You need to cite it. It's in paragraph 31, it's on internal page 22.
Taylor Wessing acted on behalf of CA.
The claimant appellant. And we say that because that was what we pleaded fairly and squarely, and it was not put in issue. And at paragraph 32, Your Honours see the two references that I've just taken Your Honours to, namely paragraphs 12 and 25 of the particulars of claim, tab 12, page 92 in the first instance, page 94 in the second instance, and they describe Taylor Wessing as then counsel. Paragraph 33, the defendant respondent has not challenged Taylor Wessing's status as acting on behalf of claimant appellant in the statement of defence or otherwise, and we say nor really could it, because if one looks at the claim form, which is behind tab 11 in bundle 1, page 87. This is the claim form. We have the issue date of the 5th of April 2017, top right-hand corner. Claim, name VTJ Limited, address, care of Taylor Wessing Middle East LLP.
Where is that reference again?
It's, if Your Honour has tab 11, page 87, that is the first page of the claim form.
Yes.
I've just taken the court to the top right-hand corner for the issue date, but the material passage is under 1 claimant, name VTJ Limited, address, care of Taylor Wessing Middle East LLP.
Is gentleman who signed the end on page 85, 89, Muhammad Ammar from Taylor Wessing?
No, I have to make that clear and make it absolutely clear that Mr. Muhammad Ahmed was not with Taylor Wessing, because from 5 you will see that who is submitting this document, firm Beitul Hikmah law firm. And that is why the pleading was on the basis of Taylor Wessing having been then counsel. But nonetheless, the address for service endures as Taylor Wessing. So what had happened is that the address for service remains the same. It's just that there had been a change of legal representative. And that explains the reference to then counsel. If I may then take the court back to my skeleton at page 22 and paragraph 33. Having identified the documents on which the first part of that paragraph is premised, we go on, had Taylor Wessing been acting at any stage before the commencement of proceedings on behalf of the defendant respondent, then in our submission there would have been the clearest possible conflict of interest. So that again gives total confidence that Taylor Wessing was acting on behalf of the claimant appellant. So we say that having established that Taylor Wessing was indeed acting on behalf of the claimant appellant, the next question is, what did he do? And I've already taken the court to paragraph 12 of the particulars claim, which pleads that it made the first payment in relation to the community check payable, or the community fee payable to luxury facilities management. And the check, which again we've seen at tab 31, has the number 603154. And I said I'd come back to the relevance of that number, and here it is. Because at paragraph 35, and for this purpose, the court needs to have bundle 2 and tab 79 open. Bundle 2, tab 79, page 281 is the first page of the 2-page document of this tab. As the court will see, it's a statement of account. It's drawn by Luxury Facilities Management, top left-hand corner. Statement date as of the 22nd of April 2013, top right-hand corner. The unit DFR P430, so we know that it's relating to the right unit. Whilst we're on page 281, just looking down at the 4th, 5th and 6th entries, the court will see that they are credit memos. That's how the document is described under document type. And then reading across, we can see that this related to December 2012, and it's identified as a credit against service charge as per HO milestone. And the milestones date back to an earlier period in 2012, but comprised, the first one is comprised within Q2 the second half year of 2012. The second one actually goes back to the 1st of January 2012, and then the third one again relates to the second half of 2012. I'll come back to the relevance of those credits in due course. But for present purposes, could I invite the court to turn the page to page 282? So that we find here a series of document numbers, RBS check number 603154. And that is exactly the check number which we have already seen behind tab 31 and drawn on the Taylor Wesson client account.
So what is the reference again?
The check is to be found at tab 31, Your Honour, bundle 1, internal page 153.
Is this tab 31?
Tab 31 in bundle 1, yes.
Yes.
So this enables us to tie up what the check was being applied for, when it was being applied, and who wrote the check. We know it's Taylor Wesson. We know they were acting on behalf of the claimant appellant. We know that the date of the check is the 25th of March 2013, which reads across to the statement of account credit on the 7th of April 2013. And we can see that that check is identified as defraying payments in relation to the capital U unit in March and April 2013. And one must recall that the defendant-respondent's case is premised on the interchange between the defendant-respondent and the claimant appellant in relation to the sale of the property and the involvement of the claimant appellant as not having taken place until September 2014. So we have clear evidence in support of the claimant appellant's case in relation to a period of time, very nearly 18 months before the defendant says the claimant was involved.
What month, 2014?
The check was drawn March 2013. The statement of account bills it to luxury facilities account on the 7th of April 2013, and the relevant date so far as the defendant's case is concerned for the claimant's involvement is September 2004.
Yes.
John, if I may revert to the skeleton argument, I know Your Honour has it loose. In the bundle it's tab 4, internal page 22, and I'm picking it up at paragraph 36, so the foot of page 22. Two other points ought to be noted from the statement of account. It is in the name of the defendant respondent, and the full statement contains several credit entries in relation to service charge, master community charge and reserve fund as per HO milestone. I already pointed that out to the court.
Where's that document?
The document reference is tab 79 in bundle 2. And this time, having looked at page 282 internally, if the court looks back to page 281,
It's on there.
and then if you read across from the transactions in AED in a dark bar, then there's a lighter grey bar, and about in the middle of the page it says description. And then if your honour goes down 5 rows, there are then 3 rows where the document type is identified as credit memo, and the description, which is set out in paragraph 36, is derived from the column headed description.
So you're talking about the service charge, budget, rate variance?
Well, they're talking about, I think, the community fee or a facilities fee. So, very, very similar to a service charge, without being held to the precise term as a term of science, yes.
What was the document number of that?
This is a document from Luxury Facilities.
Left-hand column, what is the reference?
What the relevance?
Reference. I'm trying to identify a document.
We're trying sorry, have I not given the accurate reference?
You talked about a credit memo. But
Yes, page 281. Do you want to have 281?
yes,
Under the statement of account, and then there are 2 dark grey headings.
no, I don't have colours. Okay.
Customer and unit details, and then transactions in UAE. In AED, in Durham. And under the unit details, it says DFRP 430, so we know it's the unit in question. But under transactions in AED, there's then a lighter grey bar.
Look, I've said to you, I do not have colours. Right? So you have to identify it by something tangible like a number. I've got document number column, I've got a document type column, I've got a description, and I think credit memo says PT service charge, budget rate variance. Is that what I'm supposed to be looking at?
Yes.
Debit 4,325. Yes?
It seems to be a debit of 9,867.
I don't, that's at the top.
You want the 5th, 6th and 7th entries down,
Yes.
what you're looking for, with credit memo in the second column on each occasion.
His Honour Judge Hwang is of course looking at
Yeah, I've got
the
31st
three
December now.
up from the bottom of the page.
Yeah, I see.
So it is the same page.
Yes, if you give the dates, you know, and
You have the date of the 31st of December,
yes, okay.
2012.
And which one? There are 3 of
There
them.
are 3 of them, yes.
You want me to note all 3 of them?
Well, it's simply the description. The description is common, and it's credit against service charge as per HO milestone.
Yes, and the significance of these?
The significance of that is that there was obviously delay in the construction program, such that the service provider, namely Luxury Facilities, could not levy the full service charge in relation to a property or a unit which had not reached its milestone. So we see credits being given at the end of the year for missed milestones earlier in the year. In some instances in the first half of the year, and in other instances in the second half of the year. So that is the point that we seek to make in that regard. Your Honours, what I'm then sought to do paragraph 37, which is page 23 of tab 4 in bundle 1, is to draw together the strands in relation to Taylor Wessing's involvement. We say that in the light of the analysis we've just undertaken, the full picture presented by Taylor Wessing's involvement is totally consistent with the claimant appellant's case and wholly inconsistent with the defendant respondent's. Claimant appellant's case is that although the defendant respondent remained the nominal purchaser, the claimant appellant had assumed responsibility, stood in the shoes of the defendant respondent for payments relating to the unit in 2012 and thereafter. On the other hand, the defendant respondent's case is that the claimant appellant never paid any monies attributable to the unit and didn't become involved until September 2014, and even then did not make payment. But here, having undertaken the exercise we've just gone through, the Court of First Instance had the clearest evidence that Taylor Wessing was acting on behalf of the claimant appellant in early 2013, see the check which we've seen in tab 31. Taylor Wessing was defraying charges relating to the capital U unit. We've looked at the identification on each of the documents I've taken you to, identifying that it is indeed the capital U unit. Thus, the claimant appellant was, through its lawyers, its agent lawyers, paying monies attributable to the unit at a time when, according to the defendant respondent, the claimant appellant had no involvement with the unit.
Yeah, I'm sorry, but the tab 79, we don't have any record of who paid the money. Well, the credit notes would not be payments in. So I still don't understand the big point you're trying to make from those entries about credit.
Well, the point is that it's said against us that we didn't make payments in accordance with instalments set out in the Memorandum of Understanding. And it's a way of taking the court to the evidence to show on the evidence before the court that there was delay, that service charge was a rebate, there was a credit in relation to the service charge, and that this matches up with or explains any slippage in relation to payment of instalments.
Only if you have a reconciliation. We haven't seen a reconciliation. And in any event, you pay first and argue later. So you have to pay the installments, and then if there are credits like here, you will get them credited back, but you still have to pay according to the memorandum, wouldn't you? That's how most developers would look at it.
Well, in a sense, I take Your Honour's point without accepting it, but I think that we can probably safely leave it on one side because we know from the final payment certificate, which I took the tribunal to the court to in tab 43, the first tab in bundle 2, you'll recall, Your Honour, and also the handover completion certificates, which is at the end of the previous bundle, tabs 41 and 42. We know the payment was made. So perhaps it's a rather pedestrian way of dealing with a small point which may not trouble the court.
The bottom line is that if you look at the original agreement with DAPAC and the dates of instalments, if you look at the MOU, the dates for payment there followed about 2 weeks after the date for the original payment to DAPAC. Yeah. It looks as though, from the documents you've been showing us, that there were both delays in reaching the milestones and delays in making payments to DAPAC, hence the penalties.
Yes.
And the only question really that interests me is on whose behalf was the agent making payments at the time they were made? That's the bottom line question.
That is the bottom line question.
And you say here's evidence of Taylor Wessing's cheque, and Taylor Wessing is paying on the claimant's side of the fence, and he is doing it long before any purported agreement between the defendant and the claimant plaintiff on the defendant's case.
Absolutely, Your Honour, and essentially the exercise I've just been embarked upon was taking a machete to the undergrowth to clear away the undergrowth so that one can see the simplicity of the critical question. Yes. In those circumstances, perhaps I can take the court back to paragraph 37 and go a little bit more quickly, because in essence, the point that has just been the subject of the interchange between Your Honour, Sir Jeremy Cooke and myself encapsulates the whole of paragraph 37 and certainly the remaining subparagraphs 4 and 5, which I take as read in those circumstances. Indeed, paragraph 38 can probably be taken as read too, just as Taylor Wessing was plainly acting on behalf of claimant appellant at the time, well before on defendant respondent's case, claimant appellant had any involvement. So Mr. Ariana's evidence, so having looked at Taylor Wessing and established the position there, we then turn to look at Mr. Ariana's evidence, and his evidence was that he too was acting in like manner on behalf of claimant appellant. And a bare assertion, and we say that's all it is, by the defendant respondent to the contrary, is not sufficient to put Mr. Ariana's evidence in issue, let alone to impugn it. There is a reprise in relation to Taylor Wessing, and I've set that out in the next section, but I'll go as quickly as I can. In order for a transfer of the unit, I'm now at paragraph 39 on page 24. In order for a transfer of the unit to be effected to the claimant appellant by the defendant respondent, evaluation of the unit was necessary, and our case in that regard is found at particulars of claim paragraphs 16 to 26. For the court's reference, that is tab 12, pages 93 to 94, and unless the court wishes me to take the court to those paragraphs, I would simply invite the court to read those paragraphs.
The valuation is so that the DIFC land office can assess the appropriate fee to charge, which in other countries we call stamp duty. Is that right? Which is not based on the consideration, but based on the market value. Is that why they have to have that?
Yes, and there's an issue between, because it changed from 3.5% to 5%.
That's the rate.
Yes.
But the valuation is to work on the base fee for calculation.
Yes.
And in many countries like mine, we just take the consideration, you pay the percentage on the consideration itself.
Yes.
But here that they go to the market and get a market value.
Absolutely.
And then you submit and you have to pay then the percentage.
Absolutely, Your Honour. And Your Honour will find that set out in the paragraph 16 to 26 of the particulars of claim.
So just give me the tab number of that.
It is tab 12, pages 93 to 94.
Yes, okay. Carry on.
And Your Honour's absolutely right. And in this instance, there are two valuations. One was an old valuation, which was obtained in May 2013. That's paragraph 16. And there was another new valuation because of circumstances described in the intervening paragraphs, and that was dated September 2014.
Sort of, you have it in your head, how many payments were actually made by Taylor Wessing in relation to this transaction, one way or the other?
Taylor Wessing made one and attempted to make another. So it made the luxury facilities management payment, and it was also in possession of the manager's cheque, which I've also taken to.
Okay. All right.
So paragraphs 39 and 40 on page 24 of my skeleton set out the pleadings, and I'm happy to undertake the exercise, but it's perhaps easier done in the retiring room than in plenary session. Just put the particulars of claim and the paragraphs I've identified next door to and reread sequentially with the defence and counterclaim, the paragraphs again that I've identified, to see how we put our case and how that case was responded to. And we say that undertaking that analysis, it can be seen that the defendant respondent hasn't pleaded at all to paragraph 19 of the particulars of claim, which relates to the May 2014 check, has only pleaded in part to paragraph 24 of the particulars of claim, and not at all to paragraph 25 of the particulars of claim, which relate to the attempted payment of the transfer fee to the second defendant. And that's in part depending on the manager's check, which I've already taken you to. Now, I'm aware that in paragraph 40 I've referred to paragraphs 24 and 25 of the particulars of claim. For convenience, those are then set out at paragraph 41. And at the end of paragraph 25 in the particulars of claim, there is a reference to a footnote. Now, of course, by reason of the reordering of the documents, it's important that I tell you what exhibit VTJ 11 is. And it comprises two documents which are now to be found in bundle 2 at tabs 51 and 52. And the material document is at tab 52. For the sake of absolute accuracy, the first document, which I describe as a cheque deposit form, is in fact a cash deposit advice. Is in fact yes, there's a cash deposit advice. And there's a cheque deposit form. And the relevant document is the cheque deposit form, and your honours will find the cheque deposit form at tab 52 of bundle 2, internal page 232.
Yeah, got it.
And looking at this document, we have the date, the 2nd of October 2014, in the top right-hand corner. We see that it's a cheque deposit form, and there are two cheques in question. And the total of those two cheques is 96,500 dirham, and it's in relation to unit number 30, which we can see just under the deposit receipt stamp by the HSBC Bank. Now, for present purposes, the highly material and significant entry is the first entry, which says RBS Dubai 997232, and then an extremely long set of numbers, and the amount of 78,300. Now, for convenience, what we have read there is set out in tabular form in paragraph 43 of our skeleton at the foot of page 24. Now, the reason why I've set it out in that form is because it is then convenient to take the court back in bundle 2 to tab 48, page 205 of the bundle. And your honours will then see an identicality between what we've seen in manuscript at tab 52 in relation to October 2014, and so far as the RBS Dubai cheque is concerned, it relates clearly back to what we see at tab 48, which was dated the 15th of May 2014, with identicality as to amount, long number, and cheque number. So we can draw the strands of this together, which we seek to do on the next page of our skeleton, which is paragraphs 44 and 45.
Yeah, I think unless you have something to add, we noted what you said in 45, and the point is taken. You can move on.
I'm very much obliged, Roland, and in which case I certainly won't weary the court with taking you through paragraphs 44 and 45. May I invite the court to make a marginal note that when reconsidering this aspect, if you go on to the appellant's skeleton argument by way of response, which is at tab 7, you will see at paragraphs 3 to 8, which are internal pages 69 to 70, and you'll see that we respond quite forthrightly to the way in which the respondent has put its case on the Taylor-Wessing aspect. So rather than jump around because the court has the point that I want to make, I would just invite a marginal cross-reference so that the court has the totality of our case, including our response to what the respondents have said what the respondent has said in his skeleton argument. And that response is, as I say, to be found in our response, which is tab 7, paragraphs 3 to 8, internal pages 69 and 70.
This is called appellant supplemental or supplementary skeleton argument.
Yes, what happened, Your Honour, is that at tab 6, the defendant respondent submitted a skeleton argument, and essentially around about paragraph 30, and for a few paragraphs thereafter, dealt with the check issued by Taylor-Wessing. We, under the rules, we have a right to put in a skeleton argument in response. We sought to limit that, as we made clear on page 68, paragraph 2, simply to cover points from the defendant's skeleton argument, the respondent's skeleton argument, that called for specific comment. And we felt that, having read the defendant-respondent's skeleton argument, insofar as it related to Taylor-Wessing involvement, we had to put in further response, which we've set out at paragraphs 3 to 8 in this further skeleton.
Yeah.
Thank you, Your Honour. We now move to a different aspect, but which again supports the claimant appellant's case, and that's penalties. And this is dealt with from paragraphs 46 and following in our skeleton argument. So, bundle 1, tab 4, internal page 25. And again, we've sought to set out the pleaded case, both on behalf of the claimant at paragraph 14 of the particulars of claim, tab 12, page 92, for its full context. Claimant made payment of all outstanding penalties on the unit on behalf of the first defendant and had negotiated a reduced penalty fee of 48,000. It says 635, should be 653. The defendant respondent doesn't quibble about the wrong arithmetic, but says in respect of paragraph 14 of the particulars of claim.
Sorry, where are you reading from?
I'm reading from paragraph 48 of my skeleton,
Your skeleton.
which is page 25.
Yes, I'm with you.
And this itself is an extract from the Statement of Defence and Counterclaim, which is paragraph 11 of that pleading, tab 13, page 100. In respect of paragraph 14 of the particulars of claim, wherein the claimant claims to have obtained a discount penalty fee, this is false, and a total payment of 66,130 dirham was made to Damak by the first defendant. Now, looking at Exhibit 5, now this is to be found at tab 55 and is a document that we have already looked at, so I can probably take it by finger. If I take the court to Bundle 2, tab 55,
The statement of account for
statement of account, and Your Honour was asking me why I was taking you to the penalties earlier on, and this now makes good the reason for doing so. We're back to the 3 entries towards the foot of that page, where it says, under the description, the narrative relates to penalties. And the amounts are 69,130, 20,000 odd, and 375. So, first point to deal with is, again, a typographical error. The reference to 66,000 in the pleading must in fact be to 69,130 because we're clearly talking about this aspect. On closer consideration of the document we're looking at tab 55, it can be seen that the entry for 69,130 is not the only relevant entry relating to penalties. More specifically, the following 2 entries also concern penalties. The series of 3 relevant entries are thus as follows, and for convenience, I've set it out in tabular form. Then I've sought to do an arithmetic calculation. The conclusion of the arithmetic calculation is absolutely right, but to my own embarrassment, I realise that I've made a typographical error, and the second sum in the square brackets should not be 28,851, it's 20,851, which is derived from the table and from the document that we're looking at in Bundle 2, tab 55, page 236. So my apologies for having fallen into that error, but it doesn't make any difference. It is a typographical error, but I should point it out.
the final total.
The final total is exactly is right.
Is still correct. Yeah. Okay. Go on.
And that, of course, is exactly the same sum, taking account of the transposition of figures that I identified earlier, as was pleaded at paragraph 14 of the particulars of claim. If we want to just look very briefly at paragraph 14 of the particulars of claim, it's tab 12 in Bundle 1 at page 92. No, sorry, 14 is tab 12, page 92, foot of the page, and one has AED 48635.50, that should be 653.50.
The paragraph one?
Paragraph 14.
The figure being 48,000.
48,653.50.
Okay. Go on.
And we say, the bit in brackets at the end of paragraph 50 helps explain the transposition is confirmed by reference to the relevant Damak receipt. And the relevant Damak receipt is at tab 36. And tab 36, you have the figure of £48,653.
At the end of it, the point you're trying to make is at page 12, or page 12, paragraph 55 of your skeleton, isn't it? It's not so much the nitpicking over the exact amount. And the ultimate case, I think, is still whatever the amounts were, we were paying all of this. Your client didn't pay anything. So you are saying that, well, if your client, if the first defendant was the one who was paying it, then he should know what he paid and what was.
Absolutely.
I mean, that's the big point.
In essence, yes, Your Honour, but it goes further than that, because we pleaded our case on the basis that we negotiated a discount from 69,000 odd dirham to 48,000 odd dirham, and we paid 48,000 odd dirham. The pleaded case on behalf of the defendant respondent is to say that is false. We, or I, the defendant respondent, paid the full penalty. So that what the defendant has put forward is a positive contrary case. And on analysis, that positive contrary case is clearly wrong.
Yes, so this is a credibility point.
It also goes to credibility. So we were right from the outset in relation to the way we pleaded it, and it also goes to the allegations of fraud. We were told in the pleading, in the statement of defence, that it was false.
I think we get the point, and I think you might want to move along a little quicker now.
I'm very much obliged, and I would then take as read everything through to paragraph 55, because we've summarised that in the discussion we've just had. The original against copy documents point is a relatively smaller point compared with the points it raised in relation to Taylor Wessing and in relation to penalties. Again, it's simply that the documents that the defendant respondent put forward, which were said to be duplicates, were not fully accurate duplicates. And in one material respect, namely the payment of penalties, there was a difference in the narrative between the duplicate, which was in reissue, that the defendant obtained, and the original receipt, which was provided by the claimant. And the difference in narrative was that the receipt we provided explained that it related to penalties, whereas the receipt that the defendant provided did not have the same narrative. And the defendant then said that they had applied that money in payment of an instalment, not in payment of penalties. So again, there was a material inaccuracy in the way in which the defendant respondent was putting its case. That is all summarised in paragraphs 57 to 63. Then DAMAC identification of the defendant respondent as its customer. This is the foot of page 28 in bundle 3, paragraph 64. This makes the point, which I think is now clear, that as between DAMAC, it was selling to the defendant respondent. But by dint of the memorandum of understanding, we had stepped in the shoes for the payment purposes. And therefore, it doesn't take the defendant respondent any distance to say, but look at the know your customer, look at the relationship between DAMAC and the defendant. Yes, that was how it was from the perspective of DAMAC. But DAMAC didn't need to know about the further memorandum of understanding. So
did the monk ever meet your client?
Well, DAMAC met Mr. Chiro Ariana because Mr. Chiro Ariana was making payments. So they met the agent for VTJ, yes, and he obtained
But he would have been paying on behalf of first defendant,
But so far as
Mr.
the
Al
matter is
Hassan.
concerned,
Yeah.
yes.
And there is one, like a completion meeting, I think with the, I think at the DIFC registry, and I think Mr. Chiro was present, but there is no evidence that Denmark ever knew that there was a subsale.
Nor did they need to.
Isn't that knowledge required for the notice of no objection?
Well, the notice of no objection is explored in the pleadings, and it's my understanding from the from the pleaded case that there's no issue, but that an NOC was obtained. So
What is the legal effect of an NOC, please? What is the effect of the NOC?
Well, the NOC is necessary in order to effect the transfer of title. So that was in progress.
From the original developer to the purchaser. So the NOC was actually for the benefit of the first defendant.
We can look at the way in which the matter is pleaded. If Your Honour goes to tab 12 in bundle 1. I think Your Honour will find that the relevant paragraph is paragraph 17, which is on page 93.
Yes. Yes, yes.
Following the issuance of the old valuation report, the first defendant and the claimant approached the developer to obtain the no objection certificates required by the second defendant, obviously the DIFC registrar, to effect the transfer of the unit to the claimant. So we are talking about transfer from defendant to claimant, not from DMAC to defendant. So required by the second defendant to effect the transfer of the unit to the claimant. At this meeting, a no objection certificate was signed by the first defendant authorising the transfer of the unit to the claimant, the original no objection certificate.
So at that point, they would have known of the subsale. Is that right? If not earlier.
Well, this is between... yes, because of the approach to the developer. Yes.
Okay.
Yes. Yeah.
Yeah, please carry on.
I'm delighted for that. Let me revert to the skeleton argument.
Mr. Ariane speaks to that in his evidence, because he's asked about that and says he was at the meeting and that's what happened.
I'm very much obliged, Your Honour, and I respectfully adopt that reference, yes. I was dealing with, perhaps compendiously and perhaps more quickly than I should have been, in an attempt to save time, the section between paragraph 64 and 68. So I've made submissions in relation to everything up to internal page 29. We then have the key question. Allianz and Mr. Chiro Ariana, on whose behalf did they act? Well, the first point is that the court of first instance received oral evidence from Mr. Chiro Ariana. And he said quite clearly that he was acting on behalf of VTJ, he was acting on behalf of the claimant appellant. And that is exactly consistent with the way in which the matter was pleaded, and I've taken your honours to the particular paragraphs. I've also, in earlier submissions, dealt with the non-relevance of the know your customer, because that is relevant between DMAC and Mr. Al Hassan. It's not relevant to the relationship between the claimant and the defendant. So the key question then boils down, as I say at the foot of page 29, to on whose behalf was Mr. Ariana making payment. So far as the defendant-respondent is concerned, if their case is that Mr. Chiro Ariana was their agent, one might have expected more evidence than the laconic evidence which is to be found in the first defendant's witness statement, that is tab 16, page 118. Now, it's 5 lines. Mr. Ariana was a broker I was in touch, who used to assist me as my agent. Payments due towards the purchase of the consignment would either be made by myself or Mr. Chiro Ariana on my instructions to make payment on my behalf in the event I was unavailable. No evidence of Mr. Mr. Al Hassan making any payments himself. I verbally instructed Chiro to make payments.
Sorry, this is the totality of his oral evidence. Oh, sorry, his witness.
That is the totality of the evidence with regard to Mr. Chiro Ariana in his witness statement.
Sorry, he has no other witness statements.
That's his witness statement. That's Mr. Al Hassan's witness statement. He only made one. And then this is to be contrasted or compared with what is said in the transcript. Again, you'll find the reference on my index. It's reference 9, so we're looking at transcript reference, transcript page 71. That is internal page 359 behind tab 84. And this is all that Mr. Al Hassan said in that regard. So every time you know, this is reading from the third transcript of speech down in the page, Mr. Al Hassan. So every time you know, I give him cash or like, I got it by email or sent an email to do the transaction, and I pay cash to him from another company, there is always cash for expenses. Well, no emails at all. We revert to paragraph 73 on page 30 in my skeleton behind tab 4. Same picture emerges in relation to the statement of defence and counterclaim. There, the defendant respondent contends himself with asserting that Allianz Real Estate assisted him at the time of purchase. And we go on indeed from what he pleads at paragraph 13. To be found, the statement of defence is obviously tab 13, and the page reference is page 100. From what he pleads at the statement of defence and counterclaim, paragraph 13, he, that is Mr. Al Hassan, would seem to be unsure of who exactly Mr. Ariana was, yet to recognise that Mr. Ariana was acting on behalf of the claimant appellant. Commenting on the old valuation report, he pleaded. Yes, it is.
Where are you reading from? I'm so sorry, Mr. Joyce.
I'm reading from paragraph 73 of my skeleton on page 30.
Yes, go on.
And that paragraph looks at and casts a forensic eye over what is pleaded on behalf of the defendant respondent in his statement of defence at paragraph 13 in particular, and that is page 100 at the foot of the page, where the pleading is as follows. In respect to paragraph 16, the old valuation report that has been submitted is merely a draft copy. This valuation report has been provided to an individual named Chiro Ariana. and not VTJ Limited per se? Well, that raises a number of questions. Surely, if Mr. Chairo Ariana is acting as your agent, you don't couch it in terms of provided to an individual called Chairo Ariana. And if he was acting as the agent for the defendant respondent, why did the defendant respondent seek the old valuation report back in 2013 when the defendant respondent's remaining case is that there was only discussion between the parties in September 2014. So when you look at the valuation reports, they again paint a picture which is utterly consistent with what we've seen in relation to Taylor Wessing.
At the time the valuation report was obtained, parties were ready for completion in the DIFC registry.
We say yes, because we say that this was all taking place in May 2013, and we say that this was the whole purpose for the old valuation report being obtained. And if the
And that was the point when they asked Mr. Al Hassan to come and re-execute the documents, and then he refused and asked for more money and so on.
Yeah.
That's the timeline for that.
Absolutely. And for the court's benefit, it may help just to take bundle 2 at tab 44.
What would we see there? I'm just trying to
Well,
see
you'll
if it's necessary.
see the old valuation report.
Yeah, but
And
the point is that there is a valuation report.
The point is that there is a valuation report, and the point is that that valuation report was expressly commissioned by Mr. Chairo Ariana because it says so on its face on page 173. I'm only taking you to one page, I'm not taking you to the whole valuation report.
Well, I don't know. My impression is that Mr. Al Hassan simply says whatever Mr. Ariano did, he did either on my instructions or for me. Right? I mean, that's his basic case, isn't it? As far as he deals with Mr. Ariano at all.
Well, we say that Mr. Ariana was acting for us throughout.
Yes, I understand.
But the defendant says no, he was acting for us. But the defendant also says you, the claimants, only came into the picture with regard to the purchase of this unit in September 2014. Now that begs a number of questions, and it's only the first page, it's page 173 in tab 44, bundle 2. And it says on the face, valuation of property for Mr. Chairo Ariana, retail unit P430, 14th of May 2013. Now, that document, that page, is wholly inconsistent with the defendant's case. It's irreconcilable with the defendant's case.
Are you done up to page 70, paragraph 70?
I'm very nearly done, but I will speed up because the last section deals with the plea of fraud.
Your critique of the trial judge's judgment and your comments on the fraud, I think we can take.
I'm very
one
much
outside.
obliged. Could I invite, in those circumstances, the tribunal to make, the court to make a marginal note in relation to at the end of this section, so just after paragraph 78.
Yes?
Where I say no effective challenge to Mr. Ariana's evidence was mounted. What I've tried to do on the single page that I handed in, the index to the transcripts, was to provide relevant information in relation to the following. Item 1 establishes that it was the defendant respondent's case that Mr. Ariana only became involved in September 2014, so it's a date point. The second point goes to fraud and the absence of any proper evidence. The sixth point, I'd invite the court to read all of them, but let me just highlight the sixth point is in relation to Taylor Wessing and the way in which the defendant put the case in cross-examination on Taylor-Wessing, where we say that the claimant appellant's case that Taylor-Wessing was at all material times acting on its behalf is expressly not put in issue by the defendant respondent. And defendant respondent's counsel cross-examined on the premise that Taylor-Wessing was acting on behalf of the claimant or appellant, or at least could have been, because it's expressly on the basis of even if so. And the questioning continues. So I hope that that is of assistance. Just to deal very briefly with the rest of my skeleton, the pages or paragraphs 79 through to 94 really pick up the arguments that I have put now by the voting and put them against the judgment at first instance. And why we say that the first instance judge failed to give proper weight to the evidence that was adduced on behalf of the claimant appellant. And I would invite the court just to cast an eye over that, because it pulls strands together. And then, as indeed does the next section, which is really focused to the counterclaim, but we don't need to spend time on the counterclaim because there is no appeal or respondent's notice. And then, as Your Honour has been kind enough to indicate, you have my case in relation to whether a case ought properly to be brought in the circumstances in which it should be. We say these are clearly not those circumstances. Your Honours, unless I receive a physical or a metaphorical tug on the gown from my co-counsel, those are my submissions.
Thank you. I think we'll take a break before we ask Mr. Cooper to reply. 10 minutes.
All rise, please.
Thank you very much, Your Honor. It is a pleasure to plead on behalf of the respondent defendant today. My name is Maria Ruber, lead counsel. In very brief, to the respondent's case, the appeal has no merit and it should be dismissed. It is my intent to go quite briefly over the grounds for appeal raised by the appellant, which namely are twofold. On the one hand, we have that apparently the judgment rendered by the court of first instance has been rendered against the weight of the evidence. And number two, apparently there is express premise for forgery, and this is illegitimate, deceptive, dishonest, illegal, fraudulent, and based on such apparently false claim, it should be the reason to appeal the judgment. We will start with the forgery matter, as this will be addressed quite quickly, and then we will jump on the weight of the evidence ground, which I will take a little bit longer. Before we jump into it, let's refresh, and I know it's been said before, but just to place ourselves in the situation where our client was when a complaint before the police for a forged case was registered. There was an agreement to sell in March 2012. Then apparently this was unknown to our client until 2017 when the case was filed. There was a first MOU from April 2012, and then the MOU that our client was aware of from September 2014. So 2017, the case is filed, and there is this document in front of our client that he has never signed. Okay? As it is common in the jurisdiction, our client has been here for over 30 years, has had a number of properties. He's a serious investor, so he felt very offended. He felt as a victim, so the first thing he did was to file a complaint, a police complaint, under number 194-908-2017, and this can be found in the bundle under numbers 243 and 244.
We have seen it. We've read it.
Yeah. So if there was a sincere registration, our client had never seen that document, and the case was indeed put aside based on the UAE evidence law, which requires an original. We'll just point out that it's funny, it's interesting that neither of the parties have original documents for the MOUs. We'll come back to that later. There are no original MOUs. So there was a sincere, alleged, claim for fraud that has had no bearing on the judgment on first instance. This it was dismissed and it has not been touched by the judge. So we believe that it should be dismissed. The appeal of this ground. There is no ground. Anyway, jumping on number 2, that the conclusion of the first instance was rendered against the weight of the evidence. On this end, we have 3 subheadings. Number 1, that the judgment did not take proper weight of the clear evidence of Mr. Ariana. That's number 1. Number 2, no proper weight to the relevant circumstances, and that's where Taylor-Wesson checks come in. And number 3, that the judgment failed to identify fundamental errors and impossibilities in respondent's evidence. So number 1, clear evidence. It is the claimant's position that all payments were made by Ciro Ariana on behalf of the claimant. And if you look at the proceedings on first instance, all there is in support of the claimant applicant's case is Ciro Ariana's statement saying that he made payment on behalf of the claimant. So it is the applicant's position that this should be sufficient unless Mr. Ciro Ariana is condemned as a barefaced liar. So what Mr. Ciro Ariana said, it should go, irrespective of everything else. So we are not going to look into what a barefaced liar is, but I would like to get a little bit deep into what clear evidence is. So what do we have? On the one hand, if we go to tab number 15, we have Ciro Ariana's statement. I can guide you, or I can point it out. Just in the interest of time, please guide me if you want me to cut it short. But if we go to tab number 15, this is all we have.
Yes, the witness statement of Mr. Ariana.
If we go paragraph 9,
Yes.
so all we have is a confirmation that all payments were made on behalf of the claimant. I act in a personal capacity, paragraph number 1, to manage VTJ's business interests and investment in the United Arab Emirates. Okay? However, if we dig a little bit deeper into the statement, Mr. Ciro Ariana doesn't know where the funds came from, doesn't know to which accounts they arrived. Paragraph 8, he mentions, VTJ did not maintain an active bank account in the year, so all payments to Damak and or Mohammed were made in cash. VTJ arranged for transfers into my personal account and to the account of the broker Alliance, which would then be deposited to Damak in Mohammed's name in cash.
You're reading from which paragraph?
Paragraph 8, sorry.
8, yeah?
Yes.
Oh, going back, all right.
Yeah.
Thank you.
All right. So we don't know where the funds came from. We don't know where the funds went to. Needless to say that there are no internal arrangements to document the funds paid on behalf of VTJ. Further, if we go to the Know Your Customer forms, Mr. Zero was making payments in DAMAC. If we go to tab 22, we can see a Know Your Customer form, customer name Mohd Al Hassan, name of the agent Ariana Zero, the property, the payment. If we go to tab 20, 21, 22, 23, 24, 25, 26, 27, we will find similar payments made on behalf of our client by his named agent, Mr. Zero Ariana. He had 1, 2, 3, 4 countless opportunities to document on behalf of whom payment was being made. No single. No single.
It's not very clear from the copy of tab.
No problem. Yes, let me guide you to
Sorry,
tab.
I'm asking you a question.
Yes.
What is the date of this document, please?
The date
Is it October the 2nd, 2012?
2012. Yes.
2/10/12?
Yes.
Thank you, go on.
Yes. If we go to tab 24, we will see a different payment for 300,000 dirhams, also made on behalf of Mohd Hassan, by Mr. Zero Ariana as his agent. If we go to tab 26, a payment of 390,000 dirhams on behalf of respondent, also on behalf of his agent, Mr. Zero Ariana.
These are all later, are they? Because it's still very faint.
Yeah, this one is very faint. At the end of the day, we have the clearance certificate at tab 43.
Sorry, tab 43 is in a different bundle.
Yes, bundle 2, tab 43,
Yes?
page 172.
172, yes?
We have the payment clearance certificate on behalf, what we were going over, the Know Your Customer forms, and the receipts by the MAC are the installments that were paid on behalf of the respondent. And what we are looking at now, under the payment clearance certificate, customer name is the Mohd Ammar Al Hassan respondent, and this is the full payment for the property. So we have all the Know Your Customer forms, all the payment receipts, the clearance certificate on behalf of the respondent. So, but we are trying to dig into clear evidence. If we go back to page 114, which should be the witness statement of Mr. Zero, if we go to paragraphs 21 and 22, paragraph 21, I had approached the MAC with Mohammed to obtain a new up-to-date NOC. I was informed at this point that the original documents relating to the unit were not with the MAC and was advised to take up the matter with the DIFC register.
Sorry, where are you reading from?
Paragraph 21.
Of?
Page 114, which is witness statement of Mr. Zero Ariana in tab 15.
1.5.
Yes, 1.5.
And you were reading?
Paragraph 21
Yes, okay.
and 22. The point of paragraphs 21 and 22 is that it is strange. There are many strange things in this case. It is very strange that a developer such as DAMAC or an institution like the DIFC registrar loses files. So apparently this is what happened. So we are talking about the evidence provided by Mr. Zero, whether it's credible or not. Okay. Also, Mr. Zero Ariana, how is it possible that Mr. Zero Ariana did not keep any record, no POA, no board resolution? How was the transfer going to take place? If we look at the DIFC handbook, in pages 196 and 197, we will see in page 197 that a company needs to, page 197, needs to meet certain requirements when purchasing real estate property. No board resolution, no power of attorney to anyone, to Allianz, to Taylor Wessing. We will discuss Taylor Wessing later, but nothing. We are talking about the clear evidence from Zero Ariana. It is difficult, in our opinion, based on the documents, to consider this as clear evidence. The moreover, if we consider the following, we have the agreement to sell on the 29th of March 2012 on behalf of our client. We have the recognition that Mr. Zero Ariana was a long-time friend of VTJ's directors. This is in paragraph 1, page 205, tab 15. Why would a personal friend of 20 years resell you a unit from someone who bought it 20 days ago? 20 days. You're gonna lose money. Why didn't he, if he was a 20 years long friend, why didn't he offer the property directly to VTJ? Let's keep in mind that the agreement to sell from DAMAC to the respondent or client is dated 29th of March 2012. Apparently, the unit was resold on the 19th of April 2012. I wouldn't do that to a 20-year long friend.
No, but isn't Mr. Ariana's evidence that he had advised Mr. Al Hassan to buy the unit first, and then after he had bought it, he said, I'll help you to resell it and we can then share the profit?
Correct.
So he had many clients. He might not have known that the claimant or VTJ was in the market for investment at that time, and subsequently then learned about it.
It could be.
And I believe that there were no other units available at that time. I think I recall seeing it in the note somewhere. There were no new units to be obtained directly from DAMAC.
It could be.
No, I think it's in the record somewhere. I'm sure somebody can point this out to us later on. But please carry on.
Yeah. So we have agreement to sell on behalf of our client, know your customer forms, payment receipts, all of them on behalf of our clients. No single internal document between the claimant and Allianz, or the claimant and CEO, or the claimant and the defendant on any internal payment. We have the title deed on tab 58. Tab 58 on behalf of Mr. Mohd Ammar Al Hassan, the respondent. Then we have two MOUs making reference to Alliance as intermediary. And the MOUs are in page 124.
Sorry, the tab, get the tab number.
Yeah, tab number 19. We see the MOU is in Alliance letterhead.
Yep.
If we go to page 206, which is
You're into a different tab now?
yeah. If we go to tab 49 in book number 2,
Yes.
we have another memorandum of understanding with Alliance Real Estate. Both cases, they are acting as intermediaries. The parties do not have originals. No originals were produced. Then let's look at the clear evidence. The purported payments do not match the SPA and MOU. If we look at MOU number 2 on page 206, we see.
Excuse me, how does that help?
Yeah,
Because the payments don't match any of the agreements.
nothing.
So how does it help us?
Well, even we say that MOU from 2012 never existed.
Well, I understand that.
Never.
No.
But if the claimant is to put a case that it did exist, maybe signatures are we claim that our signature is fake. But even if it was going to be accepted by action, maybe the payments could help if they are there and they match. But we say that no, there is no contract by performance. It's nowhere. There is no payment whatsoever. Whatsoever. It is our client's view is that the 9th of September 2014 there was a memorandum of understanding and a transfer, a payment needed to be made on the date of transfer. Transfer never took place because claimant never paid. And if you go to the MOU on page 206, point number 2, and this is the MOU that our client signed and is aware of. This is the part of the story that our client is aware of. Under paragraph number 2, payment was to be made by manager's check. This is what our client was expecting. And it never came. It never came. And this is the reason why the transfer did not take place. But of course, our client back in 2014 heard about VTJ. But they didn't pay.
Please carry on. Please carry on.
Then, Cleveland's counsel made a note about the evaluations. That the readings should be consistent because they knew about the evaluations and we were not aware, and this is correct, we were not aware about the evaluations. We are unaware of what happened on that end. Also, Cleveland's counsel made reference to tab 11. Sorry, and let me. I will just jump I will just close this section first, and then I will jump into the Taylor Wesson. I think it would be better not to mix subheadings. So we do not think that the evidence provided by Mr. Ciro Ariana is clear. We believe that it's full of inconsistencies. Full of inconsistencies. We, by looking at the case file, we see that all payments are made on behalf of the respondents. We have a title deed. We have the clearance certificate on behalf of our client. We have full Know Your Customer forms signed in front of Ammar, recognizing Mr. Ciro Ariana as the agent of the respondent. So we believe
that is not inconsistent with the claimant's case, because under the arrangement as pleaded by them, all of the installments that were due to the developer had to be paid by the buyer. That means to say VTJ. So on their story, VTJ had appointed Mr. Ariano to look after this transaction for them, and it's also common ground that Mr. Ariano was paying the installments of the purchase price to the developer. So that fact seems to be neutral.
Well, the point I'm trying to make is that, yes, indeed, he says that he makes payments on behalf of the claimant. But if we look at the documents when he was going to make payments, he was registering the payments as agent for the defendant.
Well, he has to, because the developer doesn't recognize VTJ.
Wouldn't be reasonable to expect an internal recognition of, I am receiving these funds from VTJ?
But there's a lot of missing internal documentation. That's true.
Wouldn't that be, I mean, we are talking about real estate. We are talking about millions of dirhams. Not millions, but more than $1 million dirhams investment. I think a little document, the moreover, when the official registered buyer is someone else, it would be safe to document a case, to at least expect that.
This sub-sale, this is called a sub-sale, an onward sale, is usually not notified to the developer unless and until it's necessary.
Yes, but when you give funds to someone, usually you have an internal receipt. I receive on behalf
But as far as Damak was concerned, Mr. Ariano was paying, and he would be representing Mr. Al Hassan.
Correct.
So the way that the form was filled up is correct, that he was acting as agent for Mr. Al Hassan for the purposes of paying installments of the purchase price to Damak.
Yeah.
What you're talking about is that internally between the buyer and the sub-buyer, that there should be some kind of, and Mr. Ariano, there should be some internal memo.
But
that's the point that you
is
can
that
make.
monies never came as per the MOU that our client is aware of. He was expecting a manager's check on the date of transfer, which is common in the jurisdiction as well.
You don't have to have managers' checks for progress payments to the developer, and those were made, and the manager's check is only, for example, for payments to government bodies and so on.
If I may guide your honors to tab 49, please. Paragraph 2 of the MOU.
Yes.
So these are the terms that the respondent was aware of, and it says, well, the buyer agrees to pay the first total amount of 1.8 by banker's draft to the seller on the day of transfer.
You're reading from paragraph 2.
Yeah. Middle of paragraph, towards the middle of the paragraph. The buyer has agreed to pay the booking deposit, which will be known by blah blah blah, while the buyer agrees to pay the rest total amount of 1.8 million dirhams by banker's draft or manager's check to the seller on the day of transfer.
But this agreement is one that the judge found he was not satisfied about, and you haven't appealed against that decision. It's not signed by the claimant, so I'm not quite sure how you can rely on it in front of us.
What do you, I mean, we're saying that there is no payments records in place. All the payments have done on behalf of our clients. And I'm trying to communicate our client's expectation in terms of payments.
To just be clear,
Yeah.
on VTJ's case, as at the date of this MOU number 2, which is September of 2014, had all the installments of the purchase price to Damak, to Daman, was it? Or Damak? Damak had been paid already by that time?
Yes, right.
Yes.
They've been paid by 2013.
Yes, that's
because we have the handover and the payment certificate.
Right. And
this
again,
recognises it in paragraph 1.
that's right.
Paragraph 1 refers to the 100% of the original price has been paid.
Yes. And is your client's case, Mr. Joyce, your client did not see this document at the time?
No,
He has not seen it until it was introduced in these proceedings.
absolutely.
Right. I suppose until Mr. Al Hassan's lawyer replied to your client's lawyer's letter, right? At that point, he.
That is certainly my understanding. We had no
Okay.
knowledge of it.
Right.
We rely on the memorandum of understanding back in April.
Each side is saying that
2012.
it had no knowledge of the other memorandum. Okay, just want to be clear that. Please carry on, Mr. Wu.
And with respect, we will jump into Taylor Wessing. It is the claimant's position that some payments were made. We discussed the community charges. Payments were made by Taylor Wessing, apparently on behalf of the claimant. We are unaware of where Taylor Wessing comes from. The position of our client is that he made payments, all due payments under the unit, to Allianz and Zero Ariana. This is our client's position. What we can only stress is that there are strange things about this as well. No power of attorney, no letter of engagement. We need to consider Taylor Wessing is a law firm registered in the DIFC. They have an obligation to keep record. It would be very simple to go and ask them, letter of engagement, when were you engaged by VTJ? Something to prove the relationship. Something minimum. Nothing has been provided. If they made some payments through Taylor Wessing, why were not all payments done through Taylor Wessing? There are many inconsistencies that I'm very sorry I cannot answer because we are limited with what we know. Our client made payments to Allianz and to Zero Ariana.
Ms. Ube, in this case, before the trial, did your client make requests from the VTJ's lawyers to produce certain documents and answer certain questions?
We asked for the original documents at the beginning. We asked for original documents which were not produced.
Did you ask, for example, for letters of retainer of Taylor Wessing and so on?
No, we didn't.
Mr. Patrick Joyce, can you assist? Was there any form of document production request between the two sides?
I was not instructed at the time, so I cannot speak from knowledge of the file contemporaneously.
Later on, somebody can
But
speak that
I am absolutely sure that if there had been a request for specific disclosure, then I would have expected that to have been on the file which was transferred from Beit al Hikmah to my co-counsel's law firm. And I would certainly have expected that global advocacy would be punctilious in observing their obligations to the court and to the disclosure process by bringing that to both my attention and to the court's attention. So on that basis, I can be fully confident that there is no such correspondence.
When did your the current law firm for your client take over? Remind us of the name of the previous
lawyer. It would have
lawyer.
been after the first instance judgment, so it would have been June. It would have been
Only at the appeal level.
only at the appeal level.
Ah. Yes, please carry on.
We will cover now the fundamental errors and impossibilities. The claimant, that the appellant claims that the judgment on first instance fails to consider fundamental errors and impossibilities from the respondent's evidence side. And by fundamental error, it refers to the wrong calculation of final penalties. Apparently, our client made payment of 69,000 penalty, 69,000 dirhams for penalty. This was really discussed. It's in tab 36 if we want to refresh ourselves. Tab 36. There was a penalty actually paid by 48,653, which is paid on behalf of our client, the respondent. Page 158, tab 36. So we do not see this as a fundamental error. Moreover, if we consider the time that has lapsed and the properties that the respondent has had and has, we do not deem it an appeal ground. So we deem that it should be dismissed on these grounds. All right. So we do not think, in conclusion, we are going to be very brief. In conclusion, we do not think that the claimant has proven the case. We have title deed, we have payment receipts for every single payment. Our client is a serious investor in the UAE, has had over 20 properties over the last 30 years. Never a single issue with their properties. It's not enough to bring a witness on a stand to claim that payments were made on someone's behalf. If I bring someone on a stand and I say I'm the owner of Burj Khalifa, I'm sorry, and I apologize for the comparison and for the example, but we are talking about real estate, and we are not buying groceries. So claimants need to document their cases, and real estate agents need to document the transactions. And this has not been done. There is an interesting question posed by the claimant, and not much has been said, but I will close with that question for the tribunal. And the question is, on whose behalf is Mr. Sirio Ariana an alliance acting? If we look at the documents, it's very clear. And that's everything, Your Honors.
Thank you.
Your Honour raised a question in the course of the learned friend submissions as to whether there were any other units available at the time, and Your Honour recalled having seen reference to the fact that there were no other units available at the time. Your Honour's recollection is indeed absolutely accurate, and the accuracy is confirmed if one looks at Bundle 2, tab 84, so in the transcript of evidence, at page 323, which is internal page 35 of the evidence. and at the top of page 323, Mr. Ariana responded in the course of cross-examination. Because Mr. Ammar, that's the defendant, bought it in 2012, and I offered to my clients because I know it was a good investment. I asked him, I told him, I have a buyer, I take forward the opportunity. Ms. Rubin, and there were no other units available. Mr. Ariana, nothing available. It was the last units available as retail in Damak. Otherwise, I was, and then there were several inaudible words. You can check also with Damak if if there was units available at that time. There was 2 units, one, and somebody else took another unit. So that
Yes. Your Honor, we're talking about a witness who doesn't know where the funds are coming from or from which accounts payments were made. So I couldn't credibility on this. I would need to verify whether any units were available or not.
Anything else, Mr.
well, with
Patrick
respect,
Joyce?
Your Honour asked a point from Your Honour's recollection, and I hope that I've provided the appropriate cross-reference for that point. Very short. The defendant-respondent must grapple with a number of points. The first point is Mr. Ariana's evidence. He said orally that he was acting on behalf of VTJ. The defendant-respondent must grapple with the second point, and that again goes to Mr. Ariana's evidence. There was no effective cross-examination of Mr. Ariana on that point. The third substantial point my learned friend must grapple with is the involvement of Taylor Wessing. The fourth substantial point is the circumstances in which the penalties came to be paid and the pleaded cases of the respective parties in that regard. And the fifth substantial point that my learned friend must grapple with is the obtaining of a valuation report, the first one being in May 2013. In our submission, the respondent has not grappled with any of those substantial points, and with regard to Taylor Wessing, the payment of penalties and the obtaining of a valuation report, all of those occurred in May 2013 or before, yet on the defendant-respondent's case, the sale from the defendant-respondent to the claimant-appellant was only first raised some 15 or 16 months later, in September 2014. You have 2 references in addition to the submissions I've made to the transcript. The relevant items are items 1 and item 8 on the index that I have provided to the court. In those circumstances, I have nothing further to add and invite the court to allow this appeal.
Thank you. Housekeeping matter, I thought I saw a schedule of costs from one of the parties.
I know that we provided a schedule of costs in proper time. There is a schedule of costs on behalf of both parties. I think it's right that I'll let the learned friend communicate when her schedule was submitted. I can submit that.
So these are noted and will be
I think
taken
we've probably
into
got it
account.
already in electronic copy, but we've handed it in hard copy form for completeness, Your Honour.
That's fine. So it's all this up.
I handed up 2. You've got enough, right?
We submitted a cost this afternoon in the office here.
Thank you. Yes, I think I've seen it. Are you just giving us extra copies? We do have it. Thank you. Just following up on the issue of costs and to try and be efficient about it, we are of the view that please sit down now. We are of the view that this case now with one appeal from the claimant, our decision on costs will simply be that it will follow the event, meaning if the appeal is allowed, then the cost will follow as a matter of course, and if the appeal is disallowed, the cost will go the other way. There doesn't seem to be any middle point here. It's either all or nothing, and unless parties have something else to say about it, then we'll take that into account when we issue our judgment and make the cost order, which will typically be that party A or party B will be entitled to their costs, the amount to be assessed by the registrar unless otherwise agreed. So we will give that order in the standard form, depending of course on which way we decide on the appeal. If there's nothing else to be said by the parties, is there anything else in terms of housekeeping before we break and adjourn?
Your Honour, we've certainly heard what Your Honour has said in relation to costs and certainly made no observations in that regard.
Ms. Uber?
No resolutions.
All rise, please.